Welcome back. I'd like to introduce our panelist, Fiona Schaeffer of Milbank, Tweed in New York, who is an international antitrust lawyer who counsels clients in a variety of industries, including healthcare, financial services, energy, media, and communications. She is the author of the amicus brief of the Association of the Bar of New York in support of neither party. Next to Fiona is David Applegate, who chairs the IP practice at Williams Montgomery here in Chicago, and he's a founding member of the Intellectual Property Institute, a member of the Federalist Society, and senior fellow for legal affairs at the Heartland Institute. He is an author of the amicus brief of the Intellectual Property Law Association of Chicago in favor of the petitioners. Tom Saunders returns this year after his first appearance at this symposium last year, and he's a partner at WilmerHale in the Washington, D.C. office. He served as counsel in landmark cases including Akamai versus Limelight, which he discussed here last year. He won a total reversal of a $1.6 billion verdict for a leading local biotech company up in North Chicago, and served as co-counsel for TiVo in TiVo versus EchoStar. He also clerked for Justice Ruth Bader Ginsburg and represented Marvel in this case. In a 6-3 decision written by Justice Kagan, affirming the Ninth Circuit's decision below, the Supreme Court held that a patent holder cannot charge royalties for the use of its invention after the patent term is expired. The court declined to overrule this 1964 decision in Brulat versus Theis, which held that a patentee's use of a royalty agreement that projects beyond the expiration date of the patent is unlawful per se. In this case, Marvel acquired Kimball's patent in 1997 as a part of settlement of Kimball's infringement claim on his patent for a spiderweb blasting toy, which I think you may see over there, but I'm not sure.
Well, we've got one of the models here. I'm informed by Marvel's attorney that there were several different iterations of this. The glove is actually a little too small for me, but might fit one of the panelists. It comes with this very nice strap-on device. And you slip around your wrist and tighten the Velcro on, which I seem to be having a little difficulty with. And then in much the same fashion as Peter Parker in the original iteration of Spider-Man in the comic books, not the more recent movie version where his webbing is organic, you strap on a little canister of web fluid. And it fits right in here like this. And then let's see, I always get this pretty much backwards. And you pull on it. And that's the water version. Mm-hmm. It also comes curiously with this Spidey Shot web fluid version, which has enough FTC and other warnings on it that I think it would probably be banned as a weapon of mass destruction if used overseas. But it tells me it will discolor furniture, apparel, clothing, and the rest of it, so I'm not going to try it. But this is at least one iteration of the toy. One of the reasons I'm pleased to be on this panel is that unbeknownst to Professor Lee and IIT Chicago Canada invited me, I'm a lifelong Spider-Man collector. And may use this later. I sold most of my comic collection years ago when it was worth about a tenth of what it would worth today. But I did keep for sentimental value, this is my oldest copy of Amazing Spider-Man #3. This is the English variant because I was living in England at the time, so this is 9 cents instead of 12 cents.
Very cool.
But it is, in all other respects, exactly as drawn by Steve Ditko and inked by Artie Simic or Sam Rosen. I have to open the Mylar bag to find out for sure. I'm not going to do that in this photo.
Is that the comic book cited by Kagan?
This is not actually, this is 3 issues later, and we can come back to that during the discussion. But this comic book, the 4th appearance of the Amazing Spider-Man in his own title, is almost as old as the precedent that my learned colleague on the right and his client did not want overturned. So we can see
Venerable.
So we can see at a glance that it is antiquated, outmoded, and should have been removed.
I sense you spent some time in front of a jury.
Yes, before starting my Supreme Court practice, I was mostly a trial lawyer.
Anyway, to wrap up, the Ninth Circuit agreed that Roulat made unenforceable the paying of royalties after the patent expired, but noted that it found the Roulat rule counterintuitive and its rationale is arguably unconvincing. I have what I'd like to have this panel be all about is a conversation between the panelists, who are the experts in this case, rather than have me leading people along by the nose. I do have an opening question, and this case was framed at one time as attending to address the statutory interpretation of 35 U.S.C. 154. Now, this may expose my ignorance about jurisdiction, but shouldn't a case that was ostensibly intended to interpret 154, shouldn't that case have gone to the Federal Circuit instead of the Ninth Circuit?
Well, I think the case was originally coming up in a breach of contract action. And so I'm not sure that was sort of front and center initially in the complaint. I mean, it featured in the defense. So I think that's why it ended up in that.
And I would agree with that. Just as tied in with the earlier panel, just as a suit for copyright royalties only, just the payment of accounting royalties, has been held not to be a case rising under the copyright laws of the United States. I think a contractual dispute here, there is no question about the infringement of the patent. The patent had been sold, as I understand it, by Kimball and his co-owners to Marvel or its predecessor. There was nothing for the Federal Circuit to interpret. It was a straight breach of contract case at that point.
I think the point that you raised, David, really underscores why the majority was wrong here. They framed this case as a case of statutory interpretation of the patent legislation. But as you say, David, no one ever suggested that that Marvel could be sued for patent infringement for non-payment of these post-termination royalties. This was a contract dispute. And the issue of post-termination royalties, if it's a contract dispute, the proper remedy would be damages. I don't see any threat or concern about extending the scope of the patent from payment of post-termination royalties, and yet that was the whole basis of the majority's decision. This is a statutory interpretation of the patent law. We don't extend the scope of the patent, and stare decisis means even if we're wrong, we're going to stick to it.
It seems to me that it's not quite that black and white with respect to the extension of the monopoly.
Well, I think the...
Because the monopoly continues to require the payment of royalties, but by only one person. And one of the comments in the case did say, yes, in fact, the monopoly is extended. And one of the issues I thought about with respect to that is, and I think that Kimball's people like to use these kinds of arguments. And by the way, I agree with them to a certain extent. In the case of developing a drug, it takes a long time. It takes a lot of money. And typically, by the time the drug is ready for market, they're right up against the end of the patent term. You know, sometimes there's time left, and there are extensions left, and so on. Well, in these days, a pharmaceutical company can file an ANDA application and get a very quick approval. So what happens to the guy that was paying the royalties and has to continue to pay the royalties? He has made a huge outlay of money. The patent term is extended. He gets beyond that period, and he is the only one that has to pay royalties on that drug. All of the other companies that come in on their own ANDAs have a distinct competitive advantage because they don't have to pay that royalty.
I don't know
I guess
who
I'm
that
not
would be.
following the question. How are they coming in if the patent is not expired?
No, what I'm saying is they're running up against the end of the patent term.
Right.
Okay, you can get approval through the ANDA if you want to go through a lawsuit before the patent expires. But when you do an ANDA filing, you're required to make what's called a paragraph 4 statement, which says you either don't infringe the patent or the patent's invalid. But more and more these days, the generics are waiting till they're running to the end of the patent term. They file their ANDA toward the end of the patent term. And the day the patent comes off term, they are on the market, literally that day.
I think that can easily be dealt with contractually. I mean, I've dealt with these situations. If you have an ANDA come in, either because the patent term has ended or because they've got a successful invalidity decision, then as licensee, I would be negotiating. These licensees know all about Hatch-Waxman, so that the post-termination royalties no longer apply in the event of generic entry. That's, I think, a pretty simple fix. As you can tell, I'm not in favor of the drill-up rule.
Didn't seem to me that too many people that were sitting on this case were in favor of it either, but nonetheless.
Right. I mean, the one thing I would say is you have to situate the Roulat rule in a larger line of cases that don't draw. I mean, you began by saying, no, this isn't a patent case. There have been a number of cases that have dealt with contractual provisions that, for reasons of patent policy, are unenforceable. The classic would be an agreement not to challenge patent, and the courts had declared that unenforceable. And before the Roulat had even been decided, you had a case called Scott Paper that looked at those rationales and said this policy is implicated not just when we're talking about provisions that affect a lot of people, but even on the level of the individual licensee, the person who has had their hands tied by these contractual provisions and is going to do so in a way when everybody else is going to be able to practice it. That's against patent policy. So that was the backdrop to Roulat in deciding that. And then the question the Supreme Court was facing was, having had this rule in place for 50 years and having had a lot of attention paid to the Patent Act in other ways, having Congress looked at the issue of drug companies 30 years after Roulat and said we're going to put in a regime of patent term extensions, coming back and moving to adjust the patent term to sync with international practice. So we have patent term extensions, patent term adjustments. So a lot of decisions that have been made along the way without Congress deciding to overturn this rule, I think led the court to say sensibly that we're going to let what has been the practice for 50 years continue to stand. And because it's statutory, Congress could change. This isn't a constitutional provision where we've tied Congress's hands. And so if this policy judgment is wrong, then Congress could change it.
But the statute says nothing about the appropriateness of royalties. The statute says for the patent term, the patentee has the right to exclude anyone practicing that same patent, that same use. It doesn't go to the issue of royalties. And the Scott decision, I mean, really says, look, any attempt to limit the licensee's post-expiration use of the product that was the subject of the patent is invalid. But again, no one here is saying that that Marvel couldn't use this product. It was a question of whether it had to pay for that use.
And that, it seems to me, is the fundamental flaw in the Kimball decision. It's confusing, on the one hand, a patent owner's right to exclude the world during the term of patent, on the one hand, from the patent owner's ability, on the other hand, to optimize revenue by structuring a license, or in this case, as I understand it, a sale of the patent rights with any given licensee for those particular optimal circumstances. And particularly when the court says, well, we're not going to overturn your lot, but here are lots of ways for people to work around it. It's a little bit disingenuous, I think, for the court to say, even 6-3, that, well, it's up to Congress to change this one.
I must say, it was a surprise to me, this decision, and I think, David, you said it so yourself. Reading the opinion, I think Kagan is one of the smartest lawyers around, and yet the justifications in her opinion, I just don't think stand up at all. The notion that this is statutory interpretation and that stare decisis, I mean, she goes so far as to say the decision's actually wrong, but we're not going to overturn it because of stare decisis. And she says that respecting stare decisis means sticking to some wrong decisions. She quotes that it's usually more important than the applicable rule of law be settled than that it be settled right. And that was kind of astounding to me, but it wasn't until I just got up here and started chatting with David about what do you think's really going on here? And it sparked a thought in my mind, which was back when I was, I think, still a law student, and we were talking about the role of stare decisis and why the court had applied it. And someone out of left field said because that judge really wants to protect the right to abortion. And I think Kagan has really neatly positioned Scalia, in a box on that issue. Now, you may think that comes completely out of left field, but I'm just recalling what was said to me on that same issue.
Although there's one very critical difference here, which is in constitutional cases, the court has tied the hands of the political branches, and so the stare decisis analysis is always looked different there than it does in statutory stare decisis, where the court can be changed at any time. And we'll see. I mean, the court already has 2 cases in this coming term where the question presented includes whether to overrule prior cases, and I think that the conventional wisdom is at least one of those you're going to see overruling. So I think this was just a very straightforward application of the principle of statutory stare decisis, which is it's an incredibly high bar to get over that because Congress could change it. And I think the court was also very cognizant of what had happened in the 1980s here, in which you had a history of other changes that were being made to patent misuse doctrines. The Senate twice passed a bill that would have overruled Clough. And in a compromise with the House says, we don't want to go as far as you're going. Let's make these changes to patent misuse and leave the rest alone. And that's what they did. So I think that history, too, which the court referred to as sort of the strongest example that it ever sees, is Congress has spurned multiple opportunities to reverse per lot, openings as frequent and clear as this court ever sees. So I think just as a matter of the principles of stare decisis and the stability in the law and the idea on statutory stare decisis that Congress can come in and create this policy, that this was an unremarkable decision in that sense. I understand that there's lots of criticism of the underlying decision, but as Justice Kagan was saying, the point of stare decisis is that it is settled and we move on until it's ruled otherwise by Congress.
And I can imagine she's going to be saying that same thing in other contexts that she cares more about.
But sticking just with this case, the curious thing that Justice Kagan says about stare decisis is that it's only important if the case is decided wrongly.
Right.
That's the only time you
It
need
matters.
it. If the case was decided correctly, of course you're going to follow the same reason because it's correct, not necessarily because it's stare decisis carved in stone. And the quotation that Fiona cited earlier to that effect was actually, which Justice Kagan did use, was actually from Justice Brandeis, but in dissent, not in a majority opinion. And as far as Thomas's point that Congress actually considered this several times, it congressionally overruling a lot and didn't do it, is Justice Alito takes that head on in the dissent and says, even where Congress has considered but not adopted legislation that abrogate a judicial ruling, it cannot be inferred that Congress's failure to act shows that it approves the ruling. And then he cites a case and quotes from that several equally tenable inferences may be drawn from such an action. So I think there really is something else going on. I'm not sure that.
What do you think it is, David?
I'm enough of a seer of the positioning of the justices and the rest of it. I think, and at least this is, I'll toss this out as a hypothesis for David and Thomas and for you, Fiona, to critique. I think that where this decision makes sense is that it does say we will follow a bright line test. And bright line tests are much easier for parties to follow, for judges to follow, and for lawyers to follow. And so I think my working hypothesis, to the extent there's anything behind the decision not disclosed in a straightforward reasoning, is just that this is going to minimize the amount of judicial time that is involved in applying a rule of reason. Because that puts you squarely in the realm of economic analysis, which the courts have been undertaking with increasing frequency over the last half century, particularly, I might add, in the realm of patent law. But this rule will minimize the amount of work that has to be done, actually, on the part of the parties, on the part of their experts, and on the part of the courts in trying to weigh this evidence. So I think to the extent that this Kimball decision has merit, other than possibly reducing the price to the consumer on Spider-Man toys, now that Marvel doesn't have to pay that owner's 3% royalty, I think is that it's a simpler guideline to follow. But I do believe it was incorrectly decided, and it is not good economic policy.
Well, it's interesting that if that's the analysis here, then the court is actually going against the weight of its decisions in closely related arenas. For example, in tying cases, in Illinois Tool Works, they rejected the per se rule in favor of a rule of reason. In resale price maintenance restrictions, the Legion case, they rejected a per se rule in favor of the rule of reason. And most interestingly to me, because this is another patent antitrust tension case in activists, the court said there is no per se legality for reverse payment settlements. If they were really acting on the basis that we like bright lines, then presumably the logic that they applied here in this case, Marvel, would apply in activists. In Marvel, they say, bad luck, it's beyond the scope of the patent patent's over, you're dead. But they don't apply that same rule the other way. If you're within the scope of the patent in a Hatch-Waxman settlement, which was always the branded pharmaceuticals argument, this is within the scope of the patent, then it should be per se lawful to have a settlement, no matter what's in it. But the court didn't do that. It applied a rule of reason. So maybe what else is going on here? I think there is a distrust of patents. I think there is a concern to rein in what Justice Kagan called the superpower of patents, and that superpower need not last or should not last any longer than the term.
But perhaps one of the other panelists or our moderator, David, would recall which case this was. It may have been Kimball, although I don't think so. But in the oral argument of a Supreme Court case, a patent case, in this latest term, I believe, the question of the percentage of patents that were upheld as valid came.
It's called Como v. Cisco.
Okay.
very interesting because it's the discussion of the presumption of validity, and the justices essentially had broad agreement from the bench that there was a coin flip, that the invalidation rates were so high.
But curiously, if I recall correctly, it was Roberts and Kagan who both sort of jumped on that point, on the same advocate, and basically were hammering in from the Chief's position and from Justice Kagan's position on the bench, and saying, so your presumption of validity is basically a coin flip. And yet in this case, of course, we have Roberts in dissent and Kagan in the majority.
Yeah, and I just think that in looking for the underlying cause, I mean, I understand that there was surprise because the conventional wisdom was when they granted it, they were going to grant to reverse. But I don't think you would have seen an opinion that was questioning a lot and then saying, but we uphold it on stare decisis anyway. And the fact that it's a per se bright line rule, I think, only came into the analysis was one of the factors that's considered in statutory stare decisis is whether the rule is workable or unworkable. And so the opinion does say the fact that this is a bright line rule has made it more workable over years. But I think this case sits nicely. I mean, the term before in the Halliburton case, the court had upheld the fraud of the market presumption. I mean, if people want to fight about what's the statutory basis for this rule, I mean, there everybody agreed that there's nothing there. It's hugely important in securities litigation, widely reviled, widely criticized, and the majority of the court said, because of stare decisis, because Congress could change this, we're going to uphold it. And the court had done the same thing in an Indian law case in Michigan v. Bay Mills. So I just say that this is a frequent pattern in the court where they will take a look, and there had been a lot of criticism here, so it's appropriate for them to take a look and say, does this rate rise to the extraordinary level where we would reverse course here? And that by and large, stare decisis is going to put a huge thumb on the scale of keeping a rule like this in place and to let Congress do the balancing if there needs to be change.
And this is a slightly different point because stare decisis was not the issue, but as long as we're talking about when the court will intervene or defer from intervening, where Congress could act, I also find this decision somewhat curious in light of the two significant Affordable Care Act cases today, Sebelius and King versus Burwell, where basically the court could have said, look, this doesn't make sense to us, send it back to Congress. The court, in fact, did take the step of making the change that Congress could have, should have, would have made. Just an observation, not particularly pertinent to the point of...
And the politics are a little different.
I mean, to the extent that bright line rules are favored because they make it easy for people and people rely on those rules, let's look at the application of it here. I mean, Kagan brings this up at one point, that there is maybe a body of licensor and licensees who relied on the Brillat rule. Presumably, those are all arrangements, licenses where there were no post-termination royalties payable because those parties knew that they would more than likely be invalid, or they found a way around Brillat. And so for those guys...
interject here for a second. There was a comment in the opinion as to the fact that a lot of people don't know about Brillat. As you said, you know, there are a lot of good license agreements now that don't have those expiration royalties. But I can tell you right now I have about 10 of these on my desk, which will not stand after this case.
Well, and that's my point. The ones that do know are not prejudiced.
Right.
And the ones that don't know get a windfall, which frankly includes Marble. I'm kind of surprised. I mean, it's a testament to your advocacy, David, I must say. But for the contracting party who contracted a fair bargain to come back and say a rule that I'd never even heard of, great, that now allows me to get out of my bargain.
Well, let's be clear here. The contract hadn't actually been interpreted. One important thing to remember in the context here is that the normal life cycle of a toy is incredibly short. The toys that last for a long period of time are the exception to the rule. And so you had a contract here that was part of the settlement of litigation. It didn't affirmatively say we're paying royalties forever. It didn't have an end date there. When you actually go to the pre-Brillat contract law, as a matter of contract law in many states, including New York State, which is important here, the default rule was for a patent license, if you don't specify an end date, we will assume, unless you say perpetual, that this will go on forever. So the court hadn't gotten to that point because Brulat was the bright line rule that cut it off before them. And I think that one of the other things that was troubling the court is, in the stare decisis context, is we just don't know. This has been on the books for 50 years. We can't tell now what the reliance interests were, whether there was someone who's making a conscious decision, whether someone was taking advantage of this. And when you're talking about opening up perpetual royalties for something without an express end date, there's a tremendous incentive to go back and find a 30-year-old contract that doesn't have an express end date and say, oh, well, we wanted this to be perpetual. And so you had a potential to really open up a can of worms there in litigation in a way that, again, Congress, because it can legislate prospectively, is in a better position to deal with it. It could come in and say, we're changing the rule going forward, but not going back, which, by the way, in the 1980s, when they were looking at overruling a lot, was exactly what they were doing. They were saying, we might change this rule, but it had provisions to say it.
But on this question of reliance, Justice Alito addressed that also in dissent, and perhaps Thomas is the attorney for Marvel in the case. You could shed some light on this. He says, the dissent says, that the court's suggestion in Kimball that some parties have come to rely on Brulat is fanciful. Its only support for this conclusion is Marvel's, his words not mine, self-serving and unsupported assertion. We do not know if Marvel's assertion is correct because Marvel has provided no evidence to support it. What was the evidence?
Well, I think that the thing that we had, I mean, number one, you have to remember, you don't build a record on stare decisis because that was up in the Supreme Court, but he ignored the citation in the majority opinion, which was from the Ekstrom licensing treatise. So here we had a major licensing treatise, and it said, quote, it is not always necessary to specify the term, i.e. the duration of the license. The duration of a license agreement that does not specify a particular term may be limited by law. For example, in the United States, the term of the license may not extend past the expiration of the license of the patent. So I think we don't know in the details. I don't have subpoena power to go into everybody's record, but you had a major licensing treatise that was telling people it's not always necessary to specify this end date, for example, and it's citing the Brulat rule here. And so I think that Justice Kagan's approach in the majority opinion is to cite that treatise, say there are arguments on both sides. At the end of the day, we as a court don't know one way or another on the reliance interests here, but that uncertainty, it cuts in favor of stare decisis.
But as Judge Easterbrook, who's no slouch when it comes to economic analysis, among other things, is concerned, this was not in a treatise, it's just a law review article, so maybe that's not as good, but again, from the dissent, Justice Alito is saying, relying on Easterbrook, that agreements to pay licensing fees after a patent expires do not, quote, enlarge the monopoly of the patent. Instead, once the patent term expires, the power to exclude is gone.
That's right.
And all that is left is, quote, a problem about optimal contract design.
Exactly.
Close quote. And that's the Easterbrook Law Review article. So certainly there is informed discourse on both sides of that question.
I must say this was not a great case to bring up to the Supreme Court to have a look at Brulat again either. I mean,
we agree. We told them this much at the search stage.
Yeah.
In this case, the government told them this much at the search
yeah.
stage. So one of the interesting things about this case too is there's an interesting intersection between copyright and patent, in the sense that unlike the prototypical example where you think of free competition when the patent expires, this was a situation where the patent was designed specifically around Marvel's intellectual property. It was a patent so you could role play as a spider person, i.e. Spider-Man. So this was an interesting situation where when the patent expires, I guess you could have market injury otherwise, but for the sort of real value driving the product here, you're not going to have market injury. No one else is going to be making another Spider-Man web blaster because of the separate rights that Marvel has. So this wasn't some of the sort of thinking about the case of, well, there's going to be free entry and you signed a bad license, and so the public's not going to bear any of the consequences of this. The reality is, if there was a perpetual license royalty here, the public was going to bear the consequences of it, because this is a situation where there would not be market.
Should I take it you've lowered the price since?
I'm not privy to decision. One of the other interesting things about the case, I mean, this is just a sort of the practicalities of how litigation starts, is that the device had morphed over a number of years from the original sort of silly string version to a multi-function version. And one of the fights was that Kimball was claiming the royalty on everything. So if they sold the Web Blaster and it got packaged with a Spider-Man mask, my royalty applies to everything. If they packaged the Web Blaster with a Spider-Man house, my royalty applies to everything. Just a little sort of the human aspect behind these suits and how sort of little fights about that and who gets the value of the follow-on contributions, the additional changes that have been made, can then launch people on this collision course of litigation that takes them all the way to the Supreme Court.
Well, I must admit I've had a little cynical take on this. Historically, there are certain vested interests that sit down and they look at the dockets and they find a case that they think may be a vehicle to get them up to the Supreme Court. One of the things I thought about this was, who would the stalking horse be here driving this? And evidently, from what you're saying, it was purely driven by inside interest. And I say I'm cynical because there's a huge anti-patent movement out there, and there are groups that are making concerted efforts to shrink the laws. But not in this case.
No, not in this case. I mean, Kimball's had gotten himself pro bono counsel who's representing him.
It's really disappointing because it is an issue that deserved good counsel, I must say.
Well, he did an excellent job. He did an excellent job.
I'm not, maligning the particular counsel, but it is a really interesting issue. I think the court got it wrong. I can tell you, I think one of the questions you asked, David, when you were circulating questions to us, was, has this been a practical concern for your clients? And I can tell you, I have spent weeks in emails, conversations, on the phone with Japanese clients who have early stage drugs that are exactly in that position where, they are not going to be able to attract licensees with any kind of, substantial royalties at the beginning. And it really does make sense to structure an arrangement that has post-expiration royalties. And they just found it extremely difficult to understand how this rule exists and how to get around it. They're very uncomfortable. So it does, in fact, I think, stifle efficient licensing.
I heard that argument, and then I looked at, I believe this may have been your brief, in terms of stifling the ability of universities to license things. In a study by Autumn, the Association of University Technology Managers, running royalties of survey respondents comprising 193 universities, hospitals, and research institutions, those that a lot of the arguments really focus on because of the long development times, increased 30% between 2011 and 2012 to $1.9 billion. The survey respondents now say that there are 40,000 active licenses ongoing right now, and these are just with universities. 10,000 products on the market that originated in academic research laboratories. Of course, so my point here is it doesn't seem like there's been too much stifling at that point. But then maybe these numbers could be twice as high.
Yeah, you'll never know what it was. I mean,
That's right.
The answer is, by definition, every patent in existence today is a patent for which was, the invention was done and was filed for after the law was on the books for a long time. So this was one of the issues that came up, is we just don't know one way or another what things would be in a world without the law. And so one of the questions Justice was asking is sort of how do things look now in terms of litigation suffering levels for
And that's kind of a hard number to ascertain, I would think. I don't know how you'd get at that number.
I don't know, I mean, maybe if there had been, different foreign practice, you look how things are playing out, but there's so many variables that change, I don't know how you prove that. And this, again, is practitioner, but one of the very difficult things about reliance interests and questions like this is a stare decisis case like this is the extremely rare case where you're litigating the issue for the very first time. Because by definition, whether to overrule the law was not the question in the lower courts. And so we are in the very strange situation of the court grants the case in December. We're arguing it by the end of March. And the court's up there saying, well, what's your empirical evidence of the reliance interest? What's your empirical evidence of this and what will happen? And there's no record that you can build on stare decisis like that, which I think is tough because the court then has to decide the stare decisis question without development.
Well, I just have one final criticism of the majority opinion.
Then I'm going to arm myself.
And it gets back to Justice Kagan's quotation, that one of the most famous lines in comic books, that with great power comes great responsibility. And she goes so far as to cite the correct page of the correct story of the correct comic, namely Amazing Fantasy 15, in which Spider-Man first appeared back in cover dated August of 1962. But what she got wrong was that Spider-Man failed to act, and that's why Uncle Ben died. And here the Supreme Court failed to act, and the lot should have done. And
You've got to write to her and tell her that,
Okay.
I think.
that's my parting comment.
Time. Thank you, panelists. We do have a few minutes for questions. Emily?
Sure. And we've explored all of those ways, the ways that Kagan cited in her opinion as well as others. But as she herself admits, that's not, it doesn't really completely get you around the inefficiencies of licensing that way. I mean, the reality is for some of these clients and some of the drugs that they're developing, it just makes sense to have a system where you are paying based on the product that's actually generated years and years later. It's not just a question of, deferring some payments or tying it to a trade secret, which frankly they were concerned someone may challenge at any time as well. That's not exactly a strong basis on which to put your economic negotiation and your return on your investment.
Anyone else?
To your point, David, about contract design, question, is it any of your sense that in the contract design literature, the economic terms, it's not just the default rules that scholars explore, it's also the penalty where we create a deliberately inefficient rule in order to force contracting parties to reveal
I would agree that I don't think the court was thinking along those lines. I think that is one way of looking at it that explains it, because in effect, as the Alito dissent says, by following the majority's suggestion that you now find ways to contract around it, you are introducing additional inefficiencies. So to that extent, I think the short answer to your question is yes.
The one conversation that this forces, because you can have differential royalty rates and your patent royalties will expire, but then your trade secret royalties or non-patent rights can continue. It does function in that sense as a clear statement rule and forces the parties to actually set those numbers. You can't just say 4% and you're fudging what's that for. They have to actually come together and have a meeting of the minds as to what these non-patent rights are actually going to be worth after the expiration.
Well, if that's all, I'd like to thank my panelists again.
Thank you, David.
Thanks, very interesting.